I'm just gonna call you Ryan, because I can't say that last name. I'm sorry.
Thank you, Mayor. Good evening. My name is Ryan Franceschina. That's my partner, CJ. I'm an attorney with GFA Law. That's me and CJ, and we represent Judge Shelena Bivens. Before I get to the substance, Judge Bivens is formally requesting an open hearing on this matter. Just want to make sure the council understands what that means under Texas law. Texas Government Code Section 551 provides that a government body shall hold an open meeting to deliberate on the dismissal of a public officer or employee if that officer or employee requests an open hearing. That is mandatory language. So this body does not have the option to move for termination into executive session tonight. If Judge Bivens requests that this deliberation be open, it must be open, and she's making that request now through counsel on the record. There's a demonstration of poor comprehension skills coming out of the building lately, and I'm here tonight to address that. Your city administrator stated on the record that Judge Bivens was being terminated, quote, because you're suing the city. That is factually wrong. No lawsuit has been filed. What the city received from my office was a cease and desist letter. A cease and desist letter is not a lawsuit. It is not a prelude to one. It is a legal notice. We identified conduct that we believed was unlawful, and we notified the city that it needed to stop. We were not threatening the city. That's all a cease and desist letter does. So let me explain what it actually said. The letter told the city in plain language that its conduct towards Judge Bivens, the proposed salary cut to $400 a month, the demand that she repay her retirement contributions, the public humiliation campaign, Chief Gregory calling her a liar at an open meeting, all of it was creating conditions that constitute constructive discharge under Fifth Circuit precedent. We cited the law, we cited specific factors. We asked the city to stop. That was not a lawsuit. It was a legal notice, and the city chose to ignore it. The city's response was to put a termination vote on tonight's agenda. So let me be very clear about what that changes tonight if the city votes to terminate Judge Bivens. Before tonight, this case involved a fact question, whether the conditions the city created were severe enough to force a reasonable person out of a job. That question requires analysis. That question has defenses. After tonight, there is no fact question. There is a city administrator on the record saying she was fired because she sued the city, meaning she asserted her legal rights. There is a city council vote formally removing a judicial officer in direct response to a cease and desist letter sent by her attorney. That is textbook First Amendment retaliation. The elements satisfy themselves. There's a second dimension to this that the council should understand. Judge Bivens is not simply a city employee. She is a judicial officer. The independence of that office is not a courtesy. It's a structural requirement. When a municipal judge knows that her position depends on the goodwill of the city council and that retaining an attorney to assert her legal rights will cost her that position, the court she presides over is no longer independent. Every ruling she makes, every case before her court is shaped by that pressure. What this council is doing tonight does not just harm Judge Bivens. It compromises the integrity of every proceeding in that court. Removing a judge because she sought legal counsel is not a personnel matter. It's judicial interference. I also want to ask this council a direct question, and I want it on the record. Is this termination in any part related to Judge Bivens' dismissal of the Winston Knowles case? Yes or no, if anyone wanted to. Because if it is, this council needs to understand what it's doing. That's not a personnel decision. That is this body using its removal power to punish a judge for a judicial ruling. That is the definition of judicial interference, and it carries its own set of legal consequences entirely separate from the First Amendment claim already on the table. This is a formal notice. If this vote proceeds, you're not resolving a personnel matter. You are creating a federal civil rights claim with the city council as the policymaker, which means Monell liability attaches to the municipality directly. Table this item. Don't be stupid. Thanks.
Thank you, sir.